There you go. All right. So last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right. So Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his count.
Welcome back, everyone. Today we're diving deep into one of the most outrageous courtroom sagas you'll ever see: multiple sovereign citizens, multiple courtrooms, and the same tired excuses recycled like old credit card statements. First stop, Michigan, where Arnold Chavez is about to test the limits of logic and legality with the classic, "You lent money to my straw man, not me," defense. If you think this is going to be a normal day in court, think again. We've got missed deadlines, massive document requests, and yes, a defendant who genuinely believes banks magically create money from his birth certificate. Stick around, because by the end of this one, you'll see why judges have zero patience for these nonsense arguments. Asterisk.
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Right away, the first red flag pops up: discovery deadlines ignored. The judge clearly gave 10 days to submit interrogatory answers. That's not optional. But here's the twist: the defendant says he didn't get the documents, while the attorney insists they were emailed. Classic sovereign citizen chaos. They try to spin procedural mistakes as legal loopholes. And then there's the jaw-dropping demand: internal Chase Bank accounting records. Folks, this isn't just overreaching, it's impossible. The court isn't your personal audit service, and expecting access to corporate-wide data is exactly why these arguments fail every single time.
No, I'm not buying that. No. Listen to me. Listen.
It's not about, I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card, you used the credit card, you have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right, Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was gonna file one, but this hearing was a little bit too early. The motion would have had to been filed the next day. So I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th, you're the problem.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating. So.
I will get that
motion
out
for
right
summary
away. I had it
disposition.
prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
Here's the moment the mask fully slips. Chavez admits to using the credit card, but now he's the lender. Suddenly, the bank borrowed money from him, not the other way around. If you're following at home, that's the classic sovereign citizen fantasy, the so-called strawman or secret treasury account. In their minds, banks are just middlemen for imaginary money, and therefore, bills don't need to be paid. But reality check, you used the card, you agreed to the terms, and yes, the balance is due. The judge isn't impressed by philosophical musings, she's looking at facts. And the facts are crystal clear.
0674, the Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed. And then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit to inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
This is a masterclass in how judges cut through nonsense. She reduces the case to 3 simple questions. Did you have the card? Did you use it? Did you fail to pay? Boom. All the strawman theories, UCC references, and accounting gibberish are instantly irrelevant. And that's exactly what makes this courtroom so intense. The drama isn't just in the defendant's fantasy, it's in watching the law strip it away piece by piece. It's almost like watching a magic trick fail in slow motion, and the audience gets to see exactly why these arguments never work. Asterisk.
All right, here's what we're going to do. I'm setting a date. So what do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay. And the court is doing so.
Well, I
Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay.
I am yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay. So you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as.
Close attention here, because this is sovereign citizen word salad at its finest. Phrases like personal security, gap accounting, and cash equivalent are thrown around, but none of them apply the way Chavez thinks they do. He's using real legal and financial terms, just not correctly. This is why these cases always end the same way: confident, misapplied terminology meets an unshakable judge. It's almost painful to watch, but also fascinating. It's like a slow-motion lesson in how not to argue a case in court. And yes, every viewer at home is silently cheering for legal reality to win, because it does.